Hello everyone and welcome to the Fox Williams travel webinar. This is our second of 2024 and today we're going to have the spotlight on EU law. So we're going to be discussing some of the changes on the horizon in relation to EU laws. So your speakers today will be myself, so I'm going to be hosting today's webinar. My name is Irena Scullion. I'm one of the partners in the travel team. We've then got the fantastic Phyllis Achiampong, who's one of the senior associates in our travel team. And I'm also delighted to be joined today by Irena Scullion, who's a tax director at Grant Thornton. So just moving on to the next slide, looking at the agenda for the day. So I'm going to be covering off proposed revisions to EU passenger rights and proposed a new proposed regulation for multimodal journeys. Phyllis is then going to be providing you with an overview of the EU Accessibility Act, and then Irena is going to be providing us with a tax update at the end of the session. So quite a jam-packed agenda there. We only have an hour. However, I am hoping that we'll have some time at the end for questions. So if you do have any questions as we go along, do put them into the Q&A functionality at the bottom of the screen, and we will try to pick them up either at the end of the session, or if we don't have time, we'll maybe just reply to the questions in the chat box. But let's see how we get on, and please do send in any questions that you have as we go along. So just on to the next slide, please. So just a couple of housekeeping points. We're obviously on webinar function, so we can't see any of you, so you don't have to worry about whether your camera's on or not. We don't have that functionality on here, so you'll only be able to see us as speakers, and the session will be recorded. And then we do send the recording out to everybody that has registered for the webinar. So moving on to our first topic, which is looking at the proposed revisions to EU passenger rights. So in November of last year, so November 2023, the European Commission set out a number of proposals which it believes will provide better rights for passengers and raise awareness of those rights. It's also looking to enhance passenger rights for bookings made through intermediaries. So these proposed revisions, if they come into force, they're going to amend the current EU passenger rights regulations that we have. So that would be EC 261 in relation to air travel, as well as EC and EU regulations relating to rail, ferry, cruise, bus and coach travel. So these revisions will be, if they are implemented, will be implemented in the form of amendments to the existing regulations. I'm going to start by looking at the proposed changes to EC 261, and that's because most of the changes that are being proposed are actually in relation to EC 261. And the main reason for that is because some of these proposed changes for EC 261 already apply in relation to rail, ferry, coach and other travel. So essentially what some of these changes are doing are essentially just bringing EC 261 into line with other passenger rights regulations. And you'll see that that's going to be a bit of a theme as we go through the changes that are being made to EU passenger rights. A lot of the changes are being implemented to bring some consistency into the regulations in relation to all modes of travel. And so that's what's happening with EC 261. I will also cover some of the changes that are being made to the other regulations as well, but the bulk of the session will focus on EC 261. So under the current rules, I think we can all agree that when passengers book air travel through an intermediary, at the moment, it's not clear from whom or when the passenger can claim a refund when a flight is cancelled. So one of the questions that we get asked quite often, and we were absolutely being asked during the pandemic, is if a flight is cancelled and you've sold that flight as part of a package, so you're a package organiser, who's actually liable to refund the customer when that flight is cancelled? And at the moment, it is unclear, and there is some overlap and there is some confusion. So under the new proposals, the EC has tried to address this And the way that they're looking to do that is to allow EU passengers to claim refunds for cancelled flights through either the intermediary or the airline. And as a result of this change, there will now also be some updated deadlines in terms of the timescales for providing those refunds. So when we talk about an intermediary, the definition that's being given is any ticket vendor or an organizer or retailer as defined in the PTD other than a carrier. So under the current EC261, there's no definition for an intermediary. So this is a new definition that's being proposed. And who we're actually talking about when we say intermediary, we're talking about travel agents, airline ticket agents, or other ticket vendors, or a tour operator who sells a package holiday, which includes a flight. So that's who we're talking about when we say intermediary. So under the revised EC261, the airline and the intermediary must agree how the passenger will receive a refund if they're due one. So who's going to make the refund? Is it going to be the airline or is it going to be the intermediary? And once that's been agreed, the airline and the intermediary must let the passenger know who will be responsible for making the refund. And that notification needs to come at the time of booking and in the booking confirmation documents. And once that's been agreed and the customer's been notified, there's then a process which must be followed. And that's going to depend on whether the airline or the intermediary is responsible for the refund. So if the airline is responsible for the refund, then it must be made directly to the customer within 7 days. And that will be either 7 days of cancellation or 7 days of the customer choosing reimbursement. So it will depend on the circumstances, but there's that 7-day deadline there for a direct refund. If the intermediary is responsible for making the refund, then the airline has to make the refund to the intermediary within 7 days. And the intermediary then has a further 7 days in which to make that refund to the customer. And if the intermediary fails to do so, the airline must make the refund to the customer. And the current wording of the revisions of EC261 actually plays an obligation on the airline to proactively do so. So the airline, if after 14 days a refund hasn't been made, the airline has to contact the customer proactively to make that refund. And the refunds have to be made back to the original payment method, both of the intermediary and the customer as applicable. And where the intermediary makes the refund, they must inform both the customer and the airline when the refund has been processed. So you can see then if the airline hasn't received that notification within 14 days, then the liability falls back to the airline to actually make that refund. The refunds must be free of charge as well. So that's just that last point on the slide. So you can't, add on admin fees or processing fees. And I think especially in relation to sort of intermediaries, admin charges and sort of booking fees, etc., are quite a common model within an intermediary model. So, something to flag is if you are responsible as an intermediary to make that refund, you can't add admin charge or other fees on to the processing of the refund. It has to be free of charge to the customer. Next slide, please. So looking now at some of the information obligations that are being proposed in relation to EC261. So a very common complaint that airlines in particular have is that when bookings are made through intermediaries, some intermediaries don't provide the customer's contact details during the booking process. They actually provide their own contact details and their own email address during the booking process. And then that means that if something does go wrong, if there is a flight delay or some kind of flight disruption, the airline cannot get in touch with the customer directly. They can only contact the intermediary. So the EC is looking to address this particular issue by now proposing that intermediaries must share the customer's contact details with the airline at the time of booking. The airline will only be permitted to use the customer's contact details to inform them of crucial travel information. So what we're looking at there is flight schedule changes, cancellations, delays, and relevant safety information. And they cannot use the information for any other purpose. So on that basis, the airline has to delete the customer's contact details within 72 hours of completion of the flight, unless the airline needs to hold on to the details for rerouting, reimbursement, or compensation. But otherwise, customer contact details must be deleted. There's also certain information obligations on the intermediary itself. So the intermediary must also share or inform the airline that it has booked a ticket for a passenger as an intermediary. It has to provide the airline with its own postal and electronic contact details. And it must also inform the airline if it wishes to receive the passengers' updates. So that last point is optional. So it's up to the intermediary as to whether they wish to receive those updates or not. But the other 2 points, that's mandatory, and that's information that the intermediary must provide to the airline. And my last point, just in relation to EC 261 revisions, is in relation to passengers with disabilities or reduced mobility. So under the new proposals, airlines and intermediaries will be required to ensure that passengers with disability or reduced mobility can travel with personal assistance, and those personal assistants can travel free of charge. And they must also make it possible for personal assistants to sit next to the passenger with disabilities or reduced mobility where it is practicable to do so. A point to note here is that these particular rights, because that's quite a significant right that's now being given to passengers with disabilities or reduced mobility, that they can now have personal assistants travel with them free of charge. But it is a right that already exists for rail, sea and road passengers. So again, it's just bringing EC 261 into line with existing EU passenger rights in relation to other modes of travel. So that moves us on quite nicely to look at the changes to all passenger rights regulations. So just next slide, please. So proposed revisions to all EU passenger rights regulations. So these proposals apply in relation to all modes of transport. So air, sea, rail, bus and coach travel. So in relation to the first proposal, there is an obligation now in relation to the management, monitoring and reporting of service quality standards. So transport operators, so this doesn't apply to intermediaries, it's operators only, but operators must set, manage and monitor certain quality service standards, and they have to capture that information in a report. And that report must cover statistics and reasons for delays and cancellations, customer complaints, and details on the way in which the operator has provided assistance to disabled passengers. And the report has to be published on the operator's website every 2 years. There's also going to be there are also some proposals around standardised compensation and refund forms. So passengers must be provided with standardised forms to use to make compensation and refund requests. And it's actually the European Commission that are going to prepare and provide these standardised forms, and they have to be accessible for persons with disabilities or reduced mobility. Now, these standardised forms will be optional for customers to use, so they're not going to be mandatory. So you won't be able to reject a complaint on the basis that a customer hasn't used a standardised form, but the standardised forms must be made available so that customers have the choice of using them if they wish to do so. And the operator or the intermediary's website must inform passengers of how the forms can be submitted, and they will also be available to download on the Commission website in all EU languages. Just next slide, please. So the last point in relation to all EU passenger rights is in relation to ADR and risk assessments. So national regulators which receive complaints from passengers, so we're talking about the Civil Aviation Authority, Trading Standards, CMA, so our national regulators. Well, that's in relation to the UK. There's obviously other national regulators in relation to the EU, but if they receive complaints from passengers, they must inform those passengers about their right to approach alternative dispute resolution bodies in order to resolve their complaint. So it's just pushing ADR forward a little bit and making sure customers are aware that they have the right to use ADR to resolve their complaint. And national regulators must also monitor operators and intermediaries' compliance with these regulations. And that's going to be through the use of risk assessments, which the provider or the intermediary must complete every 2 years. And the risk assessment shall be based on a factual assessment, which takes into account the complaints made by passengers, which have been received by the national regulator. It's also going to take into account the quality service standards report, which has to be submitted by the operator, which I was just talking about. And it will also take into account the regulator's own monitoring activities. And those activities could include audits, inspections, interviews, verifications and examination of documents as appropriate. And the activities can be both announced and unannounced activities. So quite an interesting development there in relation to how regulators have to monitor compliance with the regulations. And there's a procedure that's potentially going to be put in place if these proposals are implemented as to how national regulators are going to have to monitor compliance and this risk assessment approach. So it will be really interesting to see how this is actually going to be implemented in practice. And the last point just to mention is in relation to timescales. So as I mentioned at the beginning of the session, the proposals were published in November of last year. So it's relatively new. It's currently going through the EU legislative process, so it is still going to take a bit of time for this to go through the process, and there may well be changes as it goes through the legislative process. But we are expecting some kind of an update on this at some point this year, and of course, as soon as we do, we will update our clients and update the mailing list as soon as we do receive any kind of an update. Okay, so moving on to the next topic. So next slide, please. So looking at proposed new rights for multimodal journeys. Next slide, please, Dan. Thank you. So multimodal journeys are where travellers book a combination of different types of travel services in relation to one journey. So there's one journey, but they have a combination of flights, trains, buses, ferries. So that's considered a multimodal journey. And as I mentioned earlier, the EC is really keen to harmonise the current passenger rights framework so that passengers have consistent rights and protections throughout their journey, irrespective of their mode of transport. And that's what they're trying to do with EC 261, and that's also what they're trying to do with this proposed regulation in relation to multimodal journeys. For the regulation to apply, there has to be at least 2 different modes of transport in the customer's journey, and if there is, then this proposed new regulation would apply to that customer's journey. There are different rules which will apply depending on the type of ticket that the customer has booked. So there are 3 ticket types which are mentioned in the regulation. We've got what's called a single multimodal contract. So this is where the customer has a single contract for their journey. So it's one ticket covering the entire journey and all modes of transport within that journey. We then have a combined multimodal ticket. So this is where the customer has a ticket or tickets for a multimodal journey, but each ticket is a separate transport contract. However, those tickets have been combined by a carrier or an intermediary on its own initiative. And the tickets are purchased by means of a single payment by the passenger. So that's what a combined multimodal ticket is. And then the last ticket type that the regulations refer to is are separate multimodal tickets. So this is where the customer has a ticket or tickets for a multimodal journey, with each ticket representing a separate transport contract. But it's offered together by the carrier or the intermediary. So it's not combined as such, but they are offered to be sort of booked at the same time. But they are purchased by means of separate payments by the passenger. For a separate multimodal ticket, there has to be separate payments for each of the tickets. And you'll see as we sort of go through some of the changes, especially in relation to reimbursement and compensation, that's where it becomes quite important as to which type of ticket has the customer booked, because that's the liability and the rights that a passenger has will vary depending on the type of ticket that they have. And the other thing that the multimodal regulation is proposing is similar to what's happening with EC 261. It's to actually bring intermediaries into the mix as well. So there are obligations that are going to apply to intermediaries as well as to transport operators. And the term intermediary is widely defined as anyone acting on behalf of operators or consumers in the conclusion of transport contracts, and it includes ticket vendors, retailers, and package organisers. So quite similar to the intermediary definition for EC 261, if not slightly wider. But yeah, a wide definition there, and covers off a wide array of different types of intermediaries. Next slide, please. So looking at the key proposals. So number one is in relation to clear information and accessibility. And again, these are obligations that apply to both operators and intermediaries, and that's that they must provide clear and accessible information to passengers regarding their rights, as well as details about their journey and any potential disruption. So both planned disruption and disruption that isn't planned. And the type of, and the other, in relation to the information that must be provided, both the operator and the intermediary must inform the passenger of the type of ticket that they've booked, so whether that's single, combined, or separate, and then the rights that are associated with that ticket. So that's a key information point. And there also needs to be general guidance on minimum connecting times between the different types of transport services that are being offered in the multimodal journey. Where a booking has been made via an intermediary, there's actually the same obligations that I was just talking about in relation to EC 261, in that the intermediary must provide the customer's contact details to the carrier to allow the carrier to comply with its obligations under this regulation. So provision of information, assistance, and support. There are also certain proposals around reimbursement or rerouting in the event of a missed connection due to a delay or cancellation of a preceding transport service. And the obligations do vary depending on the type of ticket that the customer has. So for a single multimodal contract, the obligation in relation to reimbursement or rerouting will sit with the contracting carrier. However, for a combined multimodal ticket, the obligations in relation to reimbursement and rerouting will apply to either the carrier or the intermediary who has combined the tickets. So it will vary depending on the type of ticket. And there's the same rules around where a booking was made through an intermediary. There can be reimbursement to the traveller made through the same intermediary. And the rules are the same as I was just talking about for EC 261. There's also proposals in relation to assistance and support. So in the event of delays, cancellations, or misconnections, passengers should receive prompt assistance and support from transport providers. And that may include alternative transport options, accommodation, or reimbursement of expenses. And there has to be additional assistance and support for persons with disabilities and reduced mobility. There's liability for compensation for disruption. So passengers are entitled to compensation for significant delays or misconnections, except where the disruption is beyond the control of the transport operator. And just one of the key points to just mention on here is if you sell a combined multimodal ticket, then the carrier or the intermediary which has sold that combined multimodal ticket is liable to reimburse the traveller in the event of one or more missed connections. And that reimbursement and compensation is the total ticket cost plus compensation equivalent to 75% of the value of the ticket, unless the tickets were sold as separate transport contracts. And if the tickets were sold as separate transport contracts, in order to rely on that particular exemption, it has to be clear on the ticket itself that it was sold as separate transport contracts. And as a result, that means there's no right to reimbursement, rerouting, assistance, or compensation under this regulation. So again, some potential liability there for intermediaries, depending on the type of ticket that has been booked, with a potential exemption, but only if you comply with that exemption and comply with the information obligations that are applicable to that exemption. There's universal application is the key proposal really in relation to multimodal journeys. And so the purpose of the regulation is that it applies uniformly across all modes of transport involved in the multimodal journey, regardless of whether the disruption occurs during the rail, bus, ferry, or other segments of the travel. And the last point, just to mention there, is that the regulation doesn't apply where the multimodal journey is sold as part of a package, with the exception of some of the passenger rights relating to reimbursement, if reimbursement isn't provided for in the PTD. And the purpose of that is obviously just to make sure that certain passengers aren't worse off because they've booked a package holiday. If they're entitled to reimbursement under this regulation, then they'll be entitled to reimbursement even where they've booked a package. And the last point, just to say in terms of timescales, again, this regulation is going through the EU's legislative process. So we've only got the proposals at the moment. We haven't seen the actual draft regulation yet. And so as it goes through the EU's legislative process, there may be changes that are being made to the proposed rules as a result of it going through that process. We are expecting a further update at some point this year. And as always, we'll update our clients and we'll update our mailing list as soon as we receive that. Okay, so that's me done. I'm going to hand over to Phyllis now, who's going to provide us with an overview of the EU Accessibility Act. So over to you, Phyllis.
Thanks very much, Irena. And good morning, everyone. Thanks again for joining us today. So as Irena just mentioned, I'm going to spend the next few minutes talking about the upcoming EU Accessibility Act. Next slide, please, Dan. So this is going to be a bit of a whistle-stop tour of the main provisions which concern travel companies, but we'll also cover a little bit on the background and the lead up to the provisions, also the main purpose of the rules and what to expect next. And if we have enough time at the end, we'll also mention a few other new or upcoming laws to be aware of. So let's jump straight in. Next slide, please. So the EU Accessibility Act, or the EAA, as I will say going forward, it's a bit of a mouthful, is an EU directive which passed into law in 2019. Its main aim is to harmonise earlier accessibility laws for people in the EU who have long-term disabilities. Now, the definition of long-term disabilities is quite wide. This is said to include consumers who may have long-term physical, mental, intellectual, or sensory impairment. The Act also takes into consideration elderly people and pregnant women, all of whom should also benefit from these provisions. The Act also takes note and consideration of the 4 pre-existing principles or guidelines on accessibility, which we've listed out there on the slide. I'll only talk about a couple of the principles in the context of website content. So website content will only be operable if, say, someone cannot use a mouse or a traditional keyboard, but they are still able to fully operate the interface of your website. So, for instance, someone with limited use of their hands or with a long-term health condition like arthritis should still be able to use your website and navigate the menu bar or click on a tab by using something like speech recognition or speech input instead. Also, website content will be considered robust if, as assistive technology evolves, that content remains accessible and interpretable across different platforms using different devices. So, for example, again, it should be possible for someone to view the website content using an assistive device like a screen reader. So the provisions of the EEA aim to incorporate all of these principles. Next slide, please. So who is actually caught by the EAA provisions? So the provisions are quite wide. They will catch any company that is supplying the relevant product or service to consumers based in the EU, and that's regardless of whether the company itself is based in the EU or not. On the product side, this could be manufacturers, importers, or distributors. And the EAA will also catch specific types of service providers as well. So this includes providers of air, road, rail, and sea transport services. So in practice, that will cover airlines, cruise companies, international train companies as well. But we'll also, as we'll see shortly, it is likely to cover any travel agencies or tour operators selling travel services to consumers online under the e-commerce provision. Next slide, please. In terms of what may be caught by the EAA, the EU Commission has focused on consumer general purpose products and services, and we've listed these on the slide there. On the services side, you can see that different types of services are caught, but today we'll mainly focus on transport and e-commerce services as they're the most relevant. In the context of transport specifically, the relevant service caught by the EAA is the delivery of transport service information to passengers with disabilities who wish to travel. But what does this mean in practice? So next slide, please. So delivering transport service information is said to include giving passengers details about the transport service, pre-journey information, information during the journey, including in real time, information about when a service is cancelled or its departure is delayed, as well as information on prices and promotions. So if any of this information is delivered through a website, mobile app, self-service terminal, interactive screen, or even e-ticketing services, it will likely be caught by the EAA. So transport service operators, but also travel agents and tour operators all typically provide this information to consumers. And these days it's mainly online. So all of those travel companies are therefore likely to be caught by the EAA. Also, anyone selling products or services online, including travel services, is also likely to be caught by the wider e-commerce provisions in any case. Next slide, please. So we've seen who and what is caught, but we need to know what the actual requirements are. So we've listed these here. So firstly, each EU member state had until the 28th of June 2022 to transpose the directive into national law. And I'll talk a bit more about where we are with this a little later. The national laws incorporating the EEA will then take effect from the 28th of June 2025. And then from 2025, travel companies or other companies which are caught will then need to ensure that any new products or services coming onto the market will comply with the EEA accessibility requirements. Then travel companies will have another 5 years to ensure that any products or services which were in existence before the 28th of June 2025 are also updated so that they meet the accessibility requirements under the EAA. Any products or services that are non-compliant with the EEA provisions by 2030 have to be withdrawn from the market, and that's unless one of the exemptions apply, and we'll see more on the exemptions shortly. Next slide, please. So what does this mean in practice? Well, ahead of this deadline, travel companies will need to start thinking about the different ways in which they deliver transport service information and general information to consumers online. And they'll also need to find out what they need to do to become compliant with the EAA provisions. In order to do this, the EAA requires that effective companies carry out an assessment on the extent to which their products and services already comply with the relevant accessibility requirements. So in practice, this will involve carrying out reviews of websites, mobile and other online apps, any interactive information screens or self-service terminals, including the ones that display e-ticket information or other travel service information. And the companies will need to decide which of these products and services are currently designed in line with the requirements of the EAA. The assessment itself has to be captured in a written or oral format. It has to be made available to the public, so published on the company's website or within the general terms and conditions. And it needs to be accessible to people with disabilities. If the product or service does not comply with the EAA provisions, the company will need to take corrective actions to ensure that those products and services do meet the EAA accessibility requirements within the deadlines that I just mentioned, so by 2030. In that regard, the annexes within the EAA do provide some helpful guidance and examples of the types of corrective actions a company could take. So, for instance, on a website or a mobile phone app, corrective changes could include ensuring that the relevant transport service information is presented using more than one sensory channel. So, for example, having audio options for standard text, so the information can be read out to the user and they don't have to read it visually, or having options to make the text or the information larger for people who've got visual impairments. Next slide, please. So, as mentioned before, the EU member states had until the 28th of June 2022 to transpose the directive into national law, but this hasn't actually happened in practice. There are still a few states who haven't enacted the national laws to cover these provisions. But it is important to be across the national laws because some EEA provisions are actually optional for member states to include in their national laws. And some member states could also choose to add more accessibility measures which go above and beyond the requirements of the EAA. In addition to implementing the EEA directive into national law, each member state is also required to appoint a national regulator which will be responsible for overseeing the enforcement of the EEA. National regulators are expected to monitor compliance and determine the issues and determine and issue sanctions for non-compliance. And sanctions could include things like fines, orders to withdraw non-compliant products and services from the market, and in more extreme cases, it could include the imprisonment of certain company individuals. And I think we've seen that in the Irish laws that are coming up. Next slide, please. All that being said, a travel company could avoid some or all of the EAA requirements if they're able to bring themselves within one of the exemptions. So for the first set of exemptions, a company will need to be able to demonstrate that if they make some or all of the changes under the EEA, that will result in a fundamental alteration of the basic nature of the product or the service. Or if they do try to meet the EEA requirements, they will face a disproportionate burden in doing so. In order to rely on these exemptions, a company will have to conduct another self-assessment, which illustrates how the exemptions apply to them. And note that the EAA does contain certain criteria which will be taken into account. So this mainly looks at whether, in order to reach compliance, this is going to create an excessive organizational or financial burden on the company. If the answer is yes, you may be able to rely on one of those exemptions. However, there will be more to do to meet the exemption requirements. So the exemption self-assessment must be recorded in a document and retained for at least 5 years. And the company will also need to inform the relevant national regulator that they are relying on the exemption. The assessment will also have to be carried out again at least every 5 years, or if the product or service is altered, or if a national regulator requests another assessment. Next slide, please. There are also other exemptions, but I'll only talk about the first one on the slide today. So if you can demonstrate that you are a micro enterprise, and we've listed the criteria there on the slide, then you won't have to comply with any of the EEA obligations relating to the relevant services that are caught. Interestingly, but possibly not so relevant for most of the people listening today, the provisions on products will still apply to micro enterprises, but they will be more lightly applied. That being said, micro enterprises providing services or products to EU consumers are still encouraged to try and comply with the EAA requirements as much as possible. Next slide, please. So what comes next? Well, there actually isn't a lot of time left now until the relevant laws are set to come into force. So we've got just a little over a year from now. So as soon as possible, really, and if they haven't already, companies selling the relevant products and services into the EU should start looking at whether they could be caught by the provisions of the EEA. And if so, which member state laws they need to be aware of to ensure they are fully compliant. They should also be looking at the tasks they'll need to carry out to complete the relevant self-assessments. And companies should also consider whether they could fall within one of the exemptions, and if they do, the actions they'll need to take in order to meet the exemption requirements, so producing the additional self-assessments. Also, we are expecting more guidance from the EU Commission in the form of additional legislation, and in particular in relation to the criteria for exemptions. But that's it from me on the EU Accessibility Act today. So next slide, please. We thought very briefly we thought it'd be helpful to sort of talk through some of the other new or recent laws that could affect businesses. But I think in the interests of time and to ensure that we give our guest speaker, Irena, enough time to speak, I'm going to probably save this until the end and then see if we can have enough time then. So I'll hand over to Irena from Grant Thornton for our final segment now.
Thanks, Phyllis. Hi, good morning, everyone. I'm Irena Scullion. I'm a director in tax at Grant Thornton. We're one of the world's largest advisory, assurance and tax firms, and we operate across the travel and tourism sector, particularly with a lot of work with Fox Williams. So today, I just wanted to spend a few minutes providing quite a high-level tax update on the various bits and pieces that are going on. And I suppose first things first is that the nature of this sector is that it's international. Everyone is providing holidays to people away from home. And therefore, what's really important for me is the synergies between regulatory and tax. But of course, the regulatory position will always come first. So a couple of bits that I wanted to run through today was the changing view of the tour operators margin scheme with our own tax authority, but also across the European Union itself. I also wanted to just have a look at the effect of the Package Travel Directive with the creation of EU hubs and what that might mean for your businesses, and also more generally what we're seeing in the market from an advisory and corporate finance perspective. So in terms of the TOMS itself in the UK, as we all know, post the point of Brexit, statutory instrument secondary law was put in to say that the UK will retain a TOMS regime, but it will become a UK-only TOMS regime. Put very, very simply, if you are providing holidays in the UK, it will carry on as normal. If you're providing holidays outside of the UK, you will be zero rated, but still have the block on your input tax. HMRC have started to speak to myself, to various advisors, and to some of the larger entrants to the market to have a look at whether the tour operators margin scheme is fit for purpose anymore. And it ranges between abolishing it in the UK altogether on the basis that there is no real need for it anymore, arguably, or going quite the other way to bring back mandatory apportionments that used to be in place years ago for things like transport. I think what's very interesting at the moment is the political appetite to change VAT. On a completely unrelated note, I don't think I can open a newspaper without having a look at school fees and VAT. So I think a lot more will become clear after the election on this, but it will go to full consultation possibly by the end of this year. What's also interesting, again, probably not so relevant for people on this call, but I think important to mention, is the fact that there is discussions about bringing in a secondary type of margin scheme for taxi drivers, and this is completely predicated on the Uber case. So once again, we're seeing a political will and Treasury appetite to change law in a way that we haven't seen for a while for tax purposes. Then, of course, we get to the European position. And for the UK operators, post-Brexit, it has been a very, very strange and very, very stressful time with the pandemic. We've seen that in the UK, people are availing themselves of a zero rate. And then in the EU, they're not considering that they possibly have an intention to be VAT registered in those states. Germany, of course, is changing its law. Croatia is changing its law, and it's likely that more will follow. For me, what's more interesting is the package travel directive and the need potentially from a regulatory perspective, of which Irena and Phyllis can speak far more eloquently than me, to create an EU hub to be able to avail yourselves of consumer protection laws. And so what does that mean from a tax perspective? Well, it means change. And with change comes different tax aspects to consider. So there's the VAT aspect itself, which we've just very, very quickly taken a whistle-stop tour through, but there's also the wider taxes. So for a corporate tax perspective, the rates are fairly harmonised with each other across the EU, but transfer pricing, employment tax, all of those bits and pieces vastly and wildly differ from each other. So I suppose what we would advise our clients, our contacts, our friends in the industry is that when you are looking at the regulation and the law that you will have to apply yourselves to and be comfortable with, please do think about taxation at the same point to make sure that they can work as well as they can together. Indeed, Irena and I have a number of projects on together at the moment that are considering these sorts of pieces. So that's that from me with tax. More widely, I think it's important to look and be proud of the industry as it comes back better than ever after the pandemic. So our cutback economy report that we operate on a quarterly basis shows that the cost of living crisis, whilst brutal and particularly affecting of younger people, is not affecting the travel sector in the way that you would possibly expect. A lot of younger consumers are saying that they will forego shopping, they will forego restaurants so that they can travel, which is really, really impressive. We've seen that for the period to September 2024, as published about 5 months ago, there was 31.6 million atoll protected holidays sold in the UK, and that far exceeds anything before the pandemic. And we're also seeing that there's around a 63 billion holiday spend by UK residents. So what does all of that mean from an advisory perspective? It means that the deals are coming back. So there were about 40 for the travel sector in the last year, across 2020-23. Around 75% of it was to do with trade buyers, so entrance to the markets themselves, going into mergers, going into partnerships, etc. But also that private equity is back with a bang. A lot of the 3 to 5 year cycles that are normally in place for private equity portfolio companies were hugely disrupted by the pandemic. 1, because it was awful. 2, because the businesses weren't trading. And then 3, the economic hurdles that have then resulted in the cost of living crisis meant that there was uncertainty. So we're seeing now that the private equity companies will start to consider their assets, their portfolios with which to divest or reinvest, but also that new private equity houses to the market would like to potentially look to invest in the travel sector. As a tax person, this means diligence to me. And so once again, it speaks to really, really being careful and proactive around your taxation position, because either you can take a proactive approach or within a diligence proceeding, you will possibly go through some form of buy-side diligence, which is there to present risk to your business. So that is what I wanted to go through today. There are lots of different people on this call from all different types of businesses. So if you have any questions, please do feel free to ask, or if not, please do feel free to get in touch with me afterwards. But Irena and Phyllis, thank you very much for my invite this morning.
Thank you, Irena. That was really interesting. So we do have 9 minutes. So, I mean, we've got a few questions. I don't know whether, Phyllis, do you want to go back and just do your update first? Should we do that, and then we can cover off some of the questions?
Yeah, I'll just talk very briefly through these new laws that are coming up. Some are UK based, some are EU based, some are UK and EU. So the top one there, the DMCC, has actually become law now after receiving royal assent on the 24th of May 2024. And this act is going to give the CMA more powers to directly issue penalties against traders that break consumer protection law. So instead of having to go through the lengthy court procedures, the CMA now will be able to issue sort of penalties that could include large GDPR fines, style fines of up to 10% of annual global turnover. So this new act introduces a new unit within the CMA to oversee these some new consumer rules that are coming into place, and it's called the Digital Markets Unit. The Consumer Protection from Unfair Trading Regulations 2008 are also revoked. Those provisions have been moved into this new act. And additionally, there are more new consumer protection rules that have been created under the new Act, and they're going to require companies to provide consumers with clearer pricing. There's also going to be bans on fake reviews, hidden fees and drip pricing. And also there's going to be provisions for consumers to have greater control over the start and end of a subscription service. So that in that sense, it will look particularly at things like free trials and cooling off periods. So the most significant elements of the Act are expected to come into force in autumn 2024, and we're waiting for more guidance and regulations from the CMA on some of these aspects. There's also the new failure to prevent fraud offence, which has come in under the Economic Crime and Corporate Transparency Act. This received royal assent in October 2023, but I think we're still waiting for a date for these provisions to come into force. The failure to prevent fraud offence aims to hold organisations which meet certain criteria to account if they profit from fraud committed by their employees, agents, or other persons carrying out services for the company. The offence could also catch agencies or organisations based overseas if the fraud is committed under UK law or has UK victims, so it is quite far-reaching. And companies can avoid being caught by the offence if they can demonstrate that they had reasonable fraud prevention procedures in place. The new laws will strengthen existing powers to prosecute and issue unlimited fines against organisations who commit the offence. And the offence is going to apply across all sectors. So that's one to watch out for as well. And then
just very sorry to interrupt, Phyllis. Just quickly,
yes.
I'd also like just to highlight the interaction of the second, so the Economic Crime and Corporate Transparency Act, both with senior accounting officer rules from a wider tax and assurance perspective, but also corporate criminal offence. I think what's interesting is that we're seeing more and more now the regulatory piece, be it from a consumer or from a travel perspective, and taxation sort of starting to link up in a way that wasn't there 5 years ago.
Oh, wow, thank you. Yeah, helpful to know actually. So yes, please do get in touch if you think you need to try and get something into place so that you're not caught by that. But we will be issuing more kind of guidance on this. That should be coming up shortly. So very quickly, because I know time is escaping us, there are also a couple of greenwashing laws that are in the pipeline. So Just in case anyone's not aware, greenwashing is making false or misleading statements about the environmental benefits of a product or a service. So in the UK, companies regulated by the FCA will have to ensure that they follow new rules which came into force from the FCA on claims about the sustainability of a product or service. These claims have to be clear and accurate and capable of being substantiated. And these laws are set to come into effect from July this year. And then also in the EU, there's a new greenwashing directive, which intends to create another set of harmonised rules on sustainability claims. And that's going to be applicable to all companies operating in the EU or EEA. And this is going to happen by amending certain key provisions of the Unfair Commercial Practices Directive. The new rules are going to catch all sustainability claims that relate to a product, a brand, a company, or a service made in a B2C context, and it will target companies' advertising practices in particular. So we are waiting for that to also come into force, and then once it does, member states will have 2 years to transpose the law into national legislation. But yeah, that's it for now. So I'll as I said, we'll do some more updates on these laws, so watch out for those. But I'll hand back to Farina now for questions if we've got enough time.
Thank you, Phyllis. Yes, we've got a couple of minutes. So what I will do is I will go through the questions in the Q&A. So I'll just very quickly run through them. So we've got number one, what is the... So I'm assuming this is in relation to the proposed changes to EC 261. We've got a question saying, what is the likelihood of these proposals being adopted into UK 261? I mean, obviously, now that the UK is no longer part of the EU, we're not bound by these revisions. We're not bound by EU laws. However, so we could see some divergence, and actually if we don't have any changes to UK 261 and EC 261 is amended in this way, then that's going to be quite significant divergence between the two. But generally what you tend to see is that the UK does tend to follow in some way. So we saw it with PTD in terms of there was a big sort of proposal on change to PTD, and then we saw, you know, it's similar proposals in relation to PTR. So I would imagine that there will be some change coming in relation to UK 261 off the back of this, but let's see. We've got so again, I think this is in relation to EU passenger rights. Will airlines also be allowed to share information reversely to tour operators? So in the case passengers did not board. I mean, as a choice between the parties, you know, as long as you're complying with data protection laws, if there's personal data being shared, then you can share the information. I think the changes that are being made here are being mandatory information sharing because it doesn't happen at the moment. But if the parties wish to choose their information and it's within the bounds of data protection law, then they can do so. Will a multimodal contract type 1 and 2 by definition automatically qualify as package travel under the PTD? The answer to that is no, it won't, because the multimodal regulation only applies to modes of transport. So there won't be a combination of travel services. There'll only be a combination of different types of transport. So it won't qualify as a package. I will just very quickly deal with the last question. So does an EU hub for the PTD regs require having employees based in the EU? And if so, what role will those staff perform? So it will depend on the rules of the EU member state in which the hub is being set up in. So there might be a requirement. It will depend on local laws. There may be a requirement that you need to have an employee in that country, or you need to have a director that's a resident in that country, etc. So very much will depend on the EU member state in which you've decided to set up your hub. So yeah, I don't know if Irena wants to add anything to that.
Yeah, just the other point on that. So as we'd stated, regulatory trumps tax, but from a taxation position, it's really, really important that that's figured out, because you have such things on a cross-border basis as perceived UK exit charges for corporate tax. If you're removing businesses to new jurisdictions, there's the risk functionality from a transfer pricing perspective, but more widely and more broadly, there's the substance requirements from a taxation perspective, such that if you are to be tax resident in a country and regulatory resident in a country, you do need to have proper substance there, as opposed to potentially a PO box, as would have been accepted a while ago in the past.
Brilliant. Thank you, Irena. I think so. That brings us to
Oh,
1 minute past 10. So I think we'll end the webinar there. But thank you so much for joining. Thank you so much for your questions and for making this a slightly more interactive session. As I mentioned at the beginning, we will be recording this webinar. So if you've registered for it, we will be sending that out, and we will post it on our website as well. And all of the things that we've talked about here, as and when we get more updates, we will push those updates out to you so that you're aware of when changes have been made. So thank you very much, and I hope you'll have a great day. Bye-bye.